from the great state of Louisiana. I won't say Baton Rouge, but actually in New Orleans area, but he's actually a fellow Tiger. And it's very rare, Josh. I get to do a show with a fellow LSU Tiger. So thank you for coming over today, buddy, and helping us talk about this.
Happy to be here. Thanks for having me.
So, Josh, I do remember I think the biggest thing that I remember in law school, and you probably know the professor better than I can't remember his name, but we talked about longshore injuries and maritime injuries, basically, is what we were talking about. And I remember him distinctly saying, if you do your best, we will make sure, just do your best, you'll pass. Because if you ever get confronted with a case, you need to find the best expert and send that case to them, but don't try to do it yourself because you can really mess up a lot of stuff. So I don't know if that's still the case. And obviously you were a lot smarter than I was in school because you're actually doing maritime law. But you know, it's very convoluted and it can be complicated because you have a lot of moving parts, and it's not like your typical workers' comp when you get injured on a boat. You have different guidelines, I should say, and different rules.
Correct. It's a very fact-intensive analysis where we have to look at each individual case on its own, on its own, and make sure that the individual facts fit the status of the potential claimant and the jurisdiction where the case falls. Is it actually maritime or is it something else? Right.
Well, we commonly call it maritime, but it's offshore injuries. It's not longshore, but it's the Longshore Act, I guess, right?
Well, there are a couple of different acts.
Right.
So the Longshore Harbor Workers Compensation Act and the Jones Act
right.
are two major parts of the maritime personal injury litigation.
As simple as you can, explain the difference between a Jones Act and another type.
Sure. The Jones Act was an act that provides a negligence cause of action for an employee against his employer. Okay. It's unlike workers' comp, where you have you're limited to workers' compensation remedies, meaning a percentage of your wages and some medical expenses. So in the Jones Act, you can file a negligence claim and recover past lost wages, future lost wages, pain and suffering, medical expenses, and the typical damages that might be available to you in a regular cause of action.
Right. Now, longshoreman is something different, though.
Correct. A longshoreman is a classic workers' compensation regime. In other words, you don't prove fault against the employee. I'm sorry, against the employer. You just prove that you were injured in the course and scope of your employment, and then the employer, their insurance company, is on the hook for a percentage of your wages and for medical treatment.
Now, what is the difference between a Jones Act and a Longshoreman Act? I mean, how do you know what you qualify for?
That is often a very litigated issue, and we have plenty of cases going through the courts right now that I'm personally handling right now on those issues. So it depends on the status of the claimant. Okay. So in order to be covered under the Jones Act, you have to be a seaman under the Jones Act. And in order to qualify under the Longshore Harbor Workers Compensation Act, you have to be a longshoreman. There's a statutory definition of a longshoreman, and under the Jones Act, it's case law derived. So there is not a statute that defines what a seaman is. It's just a series of litigated cases over years have developed a certain test, where there are elements that we have to prove based on the facts and circumstances of that individual's employment.
So going back to my law school days, when my professor said, you find an expert that deals in this every day, it is fact intensive.
It is.
And you can make a lot of mistakes. And it sounds like, the Jones Act would be more favorable to a claimant for what they can recover versus being capped under the Longshoreman Act.
Absolutely.
Right.
So if you can qualify under the Jones Act and you were injured on a vessel, let's say for instance, and you're kind of skirting between longshore coverage and Jones Act coverage, you definitely want to try to make a play for the Jones Act seaman status so that you can avail yourselves of those additional remedies.
Right. So, and this is not just limited to Louisiana, Texas, Alabama, Florida, Mississippi. I mean, it's not state specific, it's more federally regulated, right?
Correct. This is all, maritime law originates in federal law, and so if there are cases in the state court system that apply maritime law, they're looking to federal cases. Okay.
So, the same law would apply in Panama City of the same injury that if it happens in New Orleans.
Correct.
Right.
Absolutely.
So, we talk about, workers' comp, and I think a lot of people understand workers' comp because when you get injured on your job and you're an employee, you don't sue your employer because in exchange for protection from the employer, he buys a workers' comp policy that provides him from, if he causes or creates any negligence, his employee cannot sue him directly. They're limited statutorily what they can recover and how they can recover, and there's certain guidelines. So, in a Longshoreman Act, that seems to be more typical, like a classic workers' comp. You're limited in what you can recover. And, I hate to say it like this, it may sound a little graphic, but you're more prone to have, amputees of some sort in a longshoreman's case probably than just a typical workers' comp case, because you're dealing with a lot of chains and a lot of ropes and just a lot of things that can cause much more severe injuries. And if you're capped under a longshoreman's recovery, the recoveries may be millions in differences between Jones Act and the Longshoreman Act.
That's correct. That's why you want to make sure that if there's a way that you can qualify for seaman status under the Jones Act, you want to make sure that you can try to do that to go after the remedies that you'd be entitled to as a Jones Act seaman.
Right. Now, we do have an email question that just came in, and I believe it's from, let's see here. Pat, my cousin was fishing in his pontoon boat and was hit and capsized by a bigger speedboat. He's been in the hospital for 4 days. The guy who hit him denies that it was his fault and refuses to talk to anyone. Says he had the right of way, whatever that means for a boat. Deputies are investigating, but what can my cousin's family do as far as a legal action? Would that qualify for any type of maritime issues?
If there was an incident on navigable waters, then yes, that would be a maritime claim.
Okay. And how would Pat navigate this? How would her cousin navigate this?
Well, she should definitely reach out to a maritime attorney right away to figure out what the issues are in terms of fault, where the investigation process stands, because a lot of times that investigation, depending on who's involved, can really direct how the testimony may ferret out actually in court later on.
Right. And so if they're in their pontoon boat and somebody else causes injury to them, it's not going to be a Longshoreman's Act, though. No,
this is going to be an incident between neither the Jones Act nor the Longshore Act would apply here.
Right, because you don't have an employee-employer relationship,
correct.
right? Correct. So are there any special rules that would apply in federal court under maritime law?
Well, this would be a general maritime law negligence cause of action, and potentially a claim for unseaworthiness depending on the issues that caused the collision. And so that depending on what body of water they were on, the federal rules of navigation would apply, either the inland rules or the regular rules.
Okay. And so we're both boaters. We understand that you are in charge. You're responsible for the wake that you leave. And so if you want to be real cute and run by somebody and cause a big wake to them and cause damage to them or their vessel, you actually may be responsible, even though you thought you may or may not have had the right of way. If you don't slow down and take proper care and caution, you can be negligent with your wake, and that's why you have like no wake zone sometimes to protect people's property in certain situations. But in the same way, you can't just run close to somebody if you got a bigger boat than them and just blow them off or brush them off. You can't do that.
Absolutely not. And it happens from the biggest ships to the smallest little fishing boats. The rule's the same. Wave wash, damage is an actionable claim.
Are you seeing an increase in claims? There seems to be a lot more activity on the waters now.
Certainly, we've definitely seen an uptick in claims over the last couple of years. COVID kind of put some of the activity down, but it's definitely ramping back up.
Now with that COVID, because maybe not doing a lot of commerce out there, run off back, and a lot of your activity, I guess, is in between the oil rigs and the drill ships and supply boats and stuff, right?
Absolutely. Offshore and then the intracoastal waterway, all the inland carriage that takes place where tugs are moving barges up and down the coast. That's a big part of our practice.
Well, Josh, in Panama City, we have a big tourist economy, and we have a lot of pontoon boats that are rented, wave runners that are rented. It's amazing what people will rent someone and not even get them qualified or make sure that they are certified to operate that vessel. And so what I would say to our viewing audience is make sure that when you rent a pontoon boat or you rent a wave runner of any kind, that you look to see what you're signing, because some of these releases can bar you from any claims that may or may not occur. And the injuries, as you have seen, when you have a maritime related injury, sometimes those injuries are either fatal or very, very catastrophic because you have props or you have somebody that's lost a limb.
Absolutely.
You know, and it's not typically like could be a car accident where you can have either a soft tissue type injury. You typically have a major injury.
Absolutely. It's really important for you to read over those contracts before you sign them. You want to make sure you know what's in there before you put your handwriting on the document.
Right. Because those releases are bulletproof. I do believe we have another email question that came in. Let's see, this is from Dave. Do I have a Jones Act claim if I was injured by another crew member who was horsing around? Dave, now, Josh, this is probably right up your alley here.
I'm going to give you the typical lawyer answer, which is probably not.
Okay.
You probably don't have a Jones Act claim.
Okay.
Those are difficult cases to prove because a certain level of horsing around is traditionally expected as part of Jones Act seamen living together, working together, living together every day on a boat. If the type of conduct that was involved rises to the level of something that the owner should have stepped in to prevent before, maybe that person should have never even been hired.
Okay.
That would be a potential way that you could sue them for Jones Act liability.
What if the employee is known to be very aggressive with his horsing around and it's unwelcomed and it's becoming a nuisance? Does that expose the owner of the vessel or the company to any type of Jones Act liability?
Again, possibly, but the case law is very, very difficult to overcome on horsing around. It really depends on the facts and circumstances of each situation.
Now, what about a Longshoreman Act? Does that qualify for them if they're injured by another employee? Do they get coverage under that?
They get longshore benefits, for sure.
Okay. Phone lines are open, 850-392-1544. You can always email us at lawcall@wmbb.com. We're taking your calls live now, talking about maritime law and maritime injuries. So if you got a question, feel free to give us a call. We're going to take our first break of the evening and be back in just a moment. And welcome back to Law Calls. Now we're talking about maritime injuries and accidents. So if you got a question, feel free to give us a call at 850-392-1544. You can always email us at lawcall@wmbb.com if you don't want to go on the air. We're going to pick up where we left off, Josh. We were talking about the injuries that you sustain, and if you're horsing around, that would more likely than not, unless there's some crazy facts pattern or sequence, that's going to be a Longshoreman's Act, right? And what we talked about earlier in the show, you want to try to I shouldn't say pigeonhole, but you want to try to find favorable case law and fact pattern that would help you get benefits under the Jones Act.
Yeah, let me go back to the one point earlier. So in the horsing around situation, there's probably not an actionable Jones Act claim.
Right.
But if that person's a seaman, they still would not be covered under the Longshore Act.
Okay.
So it really depends on the status of the.
So if that person's deemed so the defense would probably be trying to argue that he's a seaman,
right,
and he has no recovery.
Correct.
Because Jones Act wouldn't recover him, and Longshoreman's Act wouldn't.
And if he's excluded under the Longshore Act, then his only remedy would be under the Jones Act, and there's no cause of action,
right,
probably for horsing around.
Oh goodness. Okay. We do have another email question that came in over the break, and it's from Todd. I just took a job working on a small fishing boat. My employer says that my contract does not include Jones Act coverage. Some guys I used to work with say this is not true. What do you think? So can you enter in a contract and exclude any type of Jones Act benefits or coverage for you?
No. His friends on the boat are probably correct. I have not seen one where a contract has been enforced to say that a Jones Act seaman gives up his rights in order to recover under the Jones Act.
Right. So you can't just take a job and your employer act like he's smarter than you and say, hey, look, sign away all your rights and benefits. Right. You just can't do that.
No, it's just as a matter of law, you are a seaman and you're entitled to these remedies.
All right. Now we were talking, before the show about a case that we were both, looking at and going over the facts of someone went crazy on a boat and starts attacking other individuals on the boat.
That's a different situation.
Okay.
The type of conduct involved rises to the level of something that should never have even occurred on the boat.
Okay.
And so that really puts the Jones Act employer in an area of potential liability.
Okay. Explain and walk me through that, because maybe the employer sees the conduct and allows it to take place and doesn't.
Right. If it's somebody that's in a supervisory capacity, somebody that either a captain or a chief mate or somebody that oversees other employees on the boat, and that higher level employee is beating somebody up and the owner doesn't do anything about it, that could potentially expose the owner.
Okay. And everybody always asks you, hey, what's my case worth? I'm sure you got a ton of times. We get it all the time, and I always tell people, look, you can't tell from the get-go. You just don't know. And any attorney that tells you what your case is worth right out of the gate, you probably should look for a different attorney, because you just don't know. But I'm gonna go back to it again. These maritime injuries are substantial injuries, and the recoveries are substantial.
Right.
And if you get pigeonholed into the Longshoreman Act, where you cannot recover for the same type of injury if you were in Jones Act, it's a big difference, and it could be millions of dollars.
It is, and so there is a little nuance under the Longshore Act that provides for you to have a tort claim, in other words, a negligence claim against the vessel owner.
Okay.
And so even though you're a longshoreman, excuse me, and you recover benefits under the Longshore Act against your employer, if a vessel causes your injury, you have a negligence claim against the vessel.
Okay. Now, some vessels are worth a lot more than other vessels. Are you limited to the value of the vessel, or is there an insurance policy on the vessel?
All of that is dependent on what the defense does. There is a potential defense called the Limitation of Liability Act, where the defendants, if they don't have privity or knowledge of the facts that causes the injury or the negligence,
right,
then they could theoretically limit their liability to the value of the vessel. But if you can get around that act by showing that the owner did know what was going on,
right,
and they should have prevented it, then they're not entitled to limit their liability.
But some of these vessels have to be worth tens of millions of dollars.
Absolutely.
The
judgment collection is usually not an issue.
Right.
When you're dealing with big vessels, big commercial environment.
I do a lot of offshore fishing, so we head to the rigs all the time.
Right.
And 3 weeks ago, we were circling a drill ship, and just out of curiosity, we just Googled what would the value of this ship be, and I think Google's always got all these numbers, but it said about $250 million just for this one drill ship. And when you see these things in person, you can probably understand why it's $250 million. But if somebody were to get injured on that, obviously there's coverage there.
Right. There's going to be coverage. There's going to be way more coverage than you probably would ever need. So those issues are usually not present in those big cases.
Now you're taking these cases too. Are you taking them on a contingency fee?
Yes.
Okay. And so anybody that's injured, it's kind of like if they were to come to us, we work on a contingency fee basis to where they don't have to pay us up front. We only get paid when we recover for them.
Exactly.
And there's no money up front.
Correct. We would cover the costs of the litigation, advance those costs, and all that would just come out at the end.
Okay, gotcha. I do believe we have another email question from Marlon that just came through. What does the term navigable waters mean for Jones Act law? Somebody told me it just means the Gulf. Is that right? What about people who work on the rivers and the channels?
That's a great question. The navigable waters means navigable in fact and navigable at law. There's a two element distinction there. And so basically what it boils down to is the body of water either itself capable of interstate or foreign commerce, or connected to that body of water that is capable of interstate or foreign commerce. So in the Gulf of Mexico is a navigable waterway, the Intracoastal Waterway is a navigable waterway.
A lake wouldn't be though, right?
A landlocked lake is not.
Right.
Right.
Okay. Bays?
Bays would be navigable waterways.
Yeah. Okay.
Right.
All right. Phone lines are still open, 850-392-1544. You can always email us at lawcall@WMBB.com. We're talking about maritime injuries, and we're going to take our last break of the evening and be back in just a moment. And welcome back to Law Call. Tonight we're talking about maritime injuries. I got my good buddy and fellow LSU Tiger, Josh Marino from New Orleans area that came in. And Josh, there's a lot that goes on in these type of cases. And as my professor rings true still, Dean Sutherland, that was his name.
Right.
We talked. These are very complex cases. And, we've had cases in the past where individuals come to us not late in the game, but they come to us later in the game. And I say game, they come to us later after the accident because they tried to deal with it themselves. They tried to handle the case themselves, and because the insurance company was playing nice. Do you see a lot of that in maritime cases?
We do, unfortunately.
Okay.
It's a tragic event, and like you said earlier, a lot of these maritime cases involve catastrophic injuries. Mm-hmm. And so a lot of times these workers are in an unfortunate position of not being able to work.
Right.
And so they're dependent on their employer to try to, pay their bills, to pay their medical expenses. And so they think that the employer is going to play nice. And so they try to handle it themselves, and then that ends up sometimes, unfortunately, put them
Do
in a
you
difficult
see,
spot.
so in our personal injury world, insurance companies try to get to the client potential, you know, and say, look, you don't need an attorney. We're going to pay this and pay this, or sign this release and here's $5,000. I mean, is it employers and the insurance companies actually working against you on the maritime stuff?
Absolutely.
And so, you know, we talked about it. We work on a contingency fee basis. So basically, we're working for free. If we don't recover for you, there's no. It's the best contract you could ever enter into. If you don't recover, you don't owe us anything.
Right.
And so, by all means, you know, whether it's a personal injury case of an auto accident, medical malpractice, or even a maritime case where you're dealing with a Jones Act or Longshoreman Act, by all means, get an attorney engaged that specializes in this, that will help you, because the facts can get very complicated and you need to know what you're doing and have somebody fighting for you.
Absolutely.
So Josh, we got a little thing at the end of every show. I think you did it last year with us, you know, some shout outs. So I'm gonna let you go ahead and hit yours before I give mine, because we got to wrap up.
Yeah, I want to give my shout outs to Amanda and Cece if they're home watching. Love y'all. See y'all tomorrow.
Good deal. And I've got just a little bit more. My wife Ashley is watching tonight. Boss Man's with her. My mom is watching. Miss Pam Myers, Gary Starr, Paula Frederick, Trey Smith, Judy Smith, Rick from the Marlin, and I have two special guests that are watching this evening, Christian and Maddie. And I'm sure when I get home, they're going to critique me and tell me what I should have done better tonight. So, but anyways, thank you guys for watching tonight. Same time and same place next week. Maybe two different people here, but it'll still be Law Call with Perry and Young. So anyways, have a great weekend. And if you have any questions during the week, you can always email us at lawcall@wmbb.com, and we'll be glad to take your calls and answer your questions. So have a good evening.